Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-1004. In Re Flowers Rights Education Fund, Inc., doing business as flowersrights.org, and Paul Hudson, petitioners. Mr. Kirkpatrick for the petitioners, Mr. Tatel for the respondent.
Good morning, Mr. Kirkpatrick.
Good morning, Your Honor. May it please the court. My name is Michael Kirkpatrick, and I represent the petitioners. Section 577A of the 2018 FAA Reauthorization Act states that after notice and comment, the FAA shall issue regulations that establish minimum dimensions for passenger seats, including minimums for seat pitch, width, and length, and that are necessary for the safety of passengers. The FAA had a deadline of October 5th, 2019 to get it done. We're nearly 3 years past the statutory deadline, and the FAA has not even begun the rulemaking process. Therefore, mandamus relief is warranted, and this court should order the FAA to commence rulemaking and issue a final rule within 6 months of the court's decision. Now, the FAA argues that it's required to engage in rulemaking if and only if it determines that minimum seat dimensions are necessary for passenger safety. But that argument should be rejected for several reasons. First, the statute is written in mandatory terms.
Could you,
it says that after,
counsel, would you, as you make your argument about the interpretation of the statute, put it in terms of what your burden of proof is here? You have to show that you're clear and indisputably entitled to relief, right?
That is correct.
Okay, so we're not just interpreting the statute as we would in a Chevron case. You have to show that under this statute, you are clearly and indisputably entitled to it, right?
That is the standard,
okay.
Your Honor.
So why don't you make your argument that way?
Well, I will.
Okay. Right.
The mandatory language here, it doesn't say if necessary.
It says and.
It says and that are necessary.
Right.
And I think the most natural reading of that phrase, that are necessary for the safety of passengers, is that it indicates the criteria that the agency is to use in setting the standards, which is safety.
Suppose I asked you to buy me a car that is fast and red. Could you get me a car that's just fast without regard to color?
No,
yeah.
But here I think it's different, and I think it favors our argument, is that it says they shall issue regulations, and those regulations must be those that are necessary for safety. Safety as opposed to something else.
You shall get me a car that is fast and red.
Yes, shall give us a rule.
No, shall get me a car that's fast and red. So can you get me a car that's fast and not red?
No.
Right.
No, there are two aspects of this. One is to issue a rule setting forth minimum seat dimensions. The other aspect is that when setting those minimums, the criteria that should be used is minimums necessary for safety, as opposed to, let's say, comfort or convenience. And so
your reading of the statute, counsel, given its mandatory terms, consistent with, at a minimum, requiring the agency to issue a notice. And I'm trying to get to the point. Suppose the agency issues a notice, it receives comments, and it reviews those comments, and in its expert judgment, changes are not necessary to ensure safety of the passengers. And the agency is able to give some reasons for that. And for example, they might be in terms of the volume capacity, physical volume capacity of the plane, where you have a certain number of passengers to enable them to evacuate within what the agency determines is the time, the maximum time. In other words, as I understood your argument, maybe I misunderstood it, and maybe I misunderstood the government. I thought the resistance was not so much to having a public discussion of this issue, and with the FAA coming up with its reasons why it doesn't think any changes are necessary after considering the comments, as opposed to Congress saying, here are the seat dimensions. We've determined that those are necessary for public safety, end of discussion.
Yes, Your Honor, I think the point that we're trying to make is that currently there are no minimum seat dimensions. Congress said that the FAA shall establish minimum seat dimensions. What those are, that's going to go to the merits of the eventual rule. And maybe they're going to codify the current seat dimensions and say that those are all that is required for safety. Then maybe there will be a challenge on the merits. But the point here is that there is no regulation now on seat pitch, width, or length. Congress wants a rule on those dimensions. And to assert that it need not engage in rulemaking unless and until it decides that such a rule is necessary for safety, that would be sort of absurd, because there must be some minimum size below which safety would be impacted. And this court recognized as such in 2017.
Mr. Kirkpatrick, can you give the best case where our court has granted mandamus under the following circumstances? Number one, the agency has consistently expressed an intent to act. Right? They haven't declared we're defying a statute. That's condition number one. And condition number two, the agency's tardiness is less than 3 years. Are there any cases that fit that?
No, Your Honor, none comes to mind. I think the Peer case that we cite in our brief would be the closest. It has the first of your criteria, but it was longer than 3 years.
It sounds like we would be breaking new ground then in terms of granting mandamus under these circumstances, and we would be breaking new ground with regard to a statutory command that, even if you're right about its meaning, maybe falls short of being of you being indisputably right. And I think some of our precedents use the word indisputable as a condition for granting mandamus.
Well, Judge Walker, I would point to the fact that Congress gave a 1-year deadline to do a rulemaking, which is pretty unusual. That's a very tight time frame. And I think that shows that Congress did not want this rulemaking to lag. I would also point out that at this point, the agency is not saying they intend to do a rulemaking. In July, and you see this in their 28J letter, they solicited comments to determine whether to do a rulemaking. So they haven't even committed to doing a rulemaking. They're still trying to determine if they think they should do a rulemaking.
Let's say that we can get to the track 6 factors. The third factor, and to a degree the fifth, inquires into whether health and welfare are an issue. I want you to make an assumption that I'm sure you don't agree with, but it will help me try to figure out this case. Assume there's insufficient record evidence that agency action on seat size will mean a significant improvement in health and safety. Does that affect how we apply track?
I don't think so, because Congress thought in 2018 that there was a need for these minimums for safety. So I think Congress has already sort of made that determination that this is, in fact, something necessary for health and safety. And I don't think the agency argues that seat dimensions at some point will impact emergency evacuations. Also, it's not just emergency evacuations. There are other safety factors like brace position,
thrombosis, and they've addressed that to a degree. If car travel is more dangerous than air travel, maybe it's not, but that's sort of the conventional wisdom. You know, they say if you're afraid to fly a plane, well, don't worry, the drive to the airport was more dangerous than the flight, that kind of thing. Should that affect whether increasing seat size, which would increase the price of seats for passengers, possibly decrease the quantity of seats on a plane, would actually cost more lives than it will save?
Well, I think that's something that would go to the merits of the rule, and the agency could investigate that. And in the rulemaking, that might be a reason that they come out one way or another. Again, we're just
asking. Would it be okay to come out with the other? Come out and say the current seat sizes are sufficiently big that no regulation is necessary.
And we accept the risk that the resulting rule might not be one we like. I had hoped to reserve some time for rebuttal, but I see I've used my 10 minutes.
I'm happy to give you a couple minutes on rebuttal, but first I want to make sure that Judge Tatel and Judge Rogers don't have any other questions. Judge Rogers?
I just want to be clear as to counsel's response to Judge Walker's last question. I thought he posed a question and the answer, I don't know, didn't quite hit the nail on the head. In other words, counsel is posing that you can have a rulemaking that results in no minimum mandatory seat requirements, or wasn't that the premise of the judge's question? I just need to be clear on that.
I may have misunderstood, and I apologize if I did. I think that the statutory mandate is to have a rule that establishes minimums. What those minimums are, we understand that there's risk that the agency could say the current status quo is fine, or even move in the wrong direction. But we do think they have to establish minimums. And that's important because right now there is no rule. And so there's nothing to stop the continued sort of shrinkage of the seat dimensions.
But didn't the record, there's a letter in the record from the agency which says that seat size unlikely to go below the 28 inches. Is not unlikely to go below the 28 inches without violating other regulations, right?
That is the agency's position.
Well, but their position is that it would violate their regulations to go below it, and their conclusion is that as long as it doesn't go below 28 inches, there is no safety, as uncomfortable as they may be.
Yes, but there's two bits of speculation in the agency's position. One is that they're assuming the seat length will not drop below 18th. And they're also assuming that 9 inches of space is needed to have emergency egress after a crash and the seat has deformed. But we don't know for sure that would be necessary. And those regulations, which are independent, are a couple of decades old, and people have gotten bigger. Americans in particular have gotten bigger during that time.
Anything else, Judge Rogers?
No, thank you, Judge Walker.
Thank you, Mr. Kirkpatrick. We'll hear from Mr. Tatel.
May it please the court, Martin Tataro for the federal respondent. The Federal Aviation Administration is in the midst of collecting comments from the public addressing seat dimensions and safety. The comment period doesn't close until November 1st, but the notice has been effective in eliciting the public's views. As of yesterday, the agency has already received almost 12,000 comments. If the comments demonstrate to the agency that additional standards are necessary, it will promulgate a rule. And if the agency concludes that current standards are adequate, that decision will be subject to judicial review.
I'd like you to focus on the standard that we're applying here. And this is a mandamus action, right?
Yes, Your Honor.
Okay. So you say in your brief that the delay here is not egregious, and therefore we don't even have to engage in a discussion about what section 577 even obligates the agency to do, right?
Yes, Your Honor.
But that isn't, I'm not sure that's the way we look at mandamus. We first have to have jurisdiction. And to have jurisdiction, we have to look at the statute, don't we? We have to look at the statute to find out whether there's a clear and indisputable right to relief. If there is, then I think under our case law, then we go look at the question of whether or not the delay is egregious or not. But we first have to get over the jurisdictional hump, and I don't see how we do that without looking at the statute.
Your Honor, I'm not sure under track that's a jurisdictional.
This is before we even get to the track back. Isn't that the way mandamus works?
So our point was merely that even if there were a violation, the court could.
Oh, well, that's not what you said.
Under,
well, I wouldn't have asked the question if that's what your brief had said, but that's not what you say in the brief, right? You tell us in the brief, we do not have to engage in a discussion of what the statute means.
Right, because I think under track, it's already sort of like a presumptive jurisdiction analysis anyway. If the court disagrees, though, happy to engage with.
Well, why don't you say why don't you tell us what you think about the statute and specifically respond to your opponent's argument that, yes, it does say and affects safety, but as he points out, the agency hasn't issued a regulation at all.
Yes, Your Honor. As Your Honor pointed out, the last phrase of the statute says, and that are necessary for the safety of passengers. Under canons like the conjunctive canon, under this court's precedents like Loving versus IRS from 2014, the word and does something, and it's a requirement of the statute. So and functions as a requirement rather than as, for example, an or. And so the way the statute is phrased, it provides the administrator of the FAA with discretion to determine whether a regulation is necessary for the safety of passengers.
Well, now, one way to interpret this statute differently than I suggested is that the agency would have to issue, the agency's position is there's no safety problem unless it goes below 28 inches, right? Is that right?
That is the current position, but that said, well, the agency has also asked for public comment.
Yeah, I understand. Okay, so that's your position. So the way they comply with the congressional directive is they issue a regulation which says that at 20, if the seat if it goes below 28 inches, then here are the or it can't go below. They could issue a regulation which says it can't go below 28 inches, otherwise it would adversely affect safety. Then you would have a regulation in conformity with our Congress directive. But now the agency hasn't issued a regulation at all.
Your Honor, the agency doesn't understand Congress to have said that it needs new standards if the agency concludes that there is no current problem.
That's not what the statute says. It says you shall issue regulations regarding seat size and that affect safety. So isn't it a perfectly logical interpretation to issue a regulation which says seat size can't go below 28 inches?
It is a plausible interpretation. I don't think it's the most natural interpretation. What the statute requires is that the agency, after providing notice and comment, and here, the administrator of the FAA shall issue regulations that are necessary for the safety of passengers. And so the critical inquiry there is whether the administrator has discretion if it is not necessary for the safety of passengers to not issue a regulation. But what I think petitioner's interpretation tries to do is to sort of bring that last clause up front as a congressional finding. And so it would be a clear statement or a congressional finding that minimum seat dimensions are necessary for the safety of passengers. And then the statute would proceed, not after a year, the FAA administrator shall issue a regulation. But that is demonstrably not how the statute is written. Instead, the agency interprets Section 577 to be demanding from the agency to get information from the public to take a fresh look anew at the connection between seat dimensions and passenger safety. And that is also in conjunction with Section 337, which also says study again.
There might be a third way to read that last clause that, that's necessary for safety. The first clause describes the topic. They shall issue regulations about seat size. And then the second clause might limit the types of seat size regulations that can be promulgated. So if absent the second clause, FAA might be able to limit seat size based on comfort. The second clause says no, you're only allowed to make your decision when it's based on safety. What's wrong with that?
I think the question there, Your Honor, would be whether if the agency has determined that no further regulations are necessary for safety, whether it has to nonetheless regulate in this field, which would be a regulation that essentially means
I think based on what you just said, then it wouldn't really matter whether the statute's phrased the way it currently is, which is that, ... and that. It could just be that, ... period, end of sentence. And then the next sentence could say, those regulations must be based on safety factors, not comfort factors.
Your Honor, I think if the and clause were removed altogether, then that would be an affirmative obligation to regulate regardless of the necessary for safety clause.
Even if the next sentence said what I just said?
And then if the next sentence was framed as a sort of description of what came before, then I think that's probably a closer case. And I think that could potentially still be a case in which a regulation wouldn't be necessary. No further regulation would be necessary if the agency determines that the current regulatory scheme protects the safety of passengers.
Can I get clarification on the status of notice and comment? It sounded like when you started out today, you said that the notice and comment, formal notice and comment period had begun. Did I understand that right?
No, Your Honor, the agency has asked the public for notice and comment. There's
been no proposed rulemaking.
Right. The difficulty here is that the statute is vague in several respects, including this particular respect, what it means by notice and comment. To be clear, the agency has not engaged in a notice of proposed rulemaking. It has just sent out a notice to the public to receive comments to further educate the agency. And one important component I want to emphasize about the notice is it didn't just say, public, send us what you got. Instead, it said, what would be most helpful to us is technical data that demonstrates any potential connection. And so it's seeking a very specific kind of information, but of course—
Will there be a notice of either proposed rule or the notice of a decision to not propose a rule followed by a comment period for that?
I think the agency, if I understand, there will not necessarily be a notice of proposed rulemaking, but the agency will announce the results if it determines after reviewing all of the thousands of comments that no further regulations are necessary. And then that order, decision statement, whatever it's called, will be a final agency action subject to review under 49 USD 46110. And so the critical point here is that either petitioners will get a rule that they're seeking, or there will be an order that is subject to review in this court or wherever the petitioner resides. And
do you have a guess on when that would happen?
I don't. It's impossible to say just because historically most of the comments have been sent in toward the end of the comment period deadline. And this is rather unique in that the public seems very engaged with this issue, and the agency's just received thousands and thousands and thousands of comments, and it wouldn't surprise me if the majority of those—
I'm not saying we would do this, but if we were to issue an order requiring you to submit a schedule for when either proposed rule will be made or a decision to not propose a rule will be made, you wouldn't be able to satisfy that order?
So, Your Honor, I think as cases like Barr Laboratories demonstrate, there's no need for the court to retain jurisdiction in that scenario. But of course, it's within the court's discretion. And my only point is that the agency would have a clearer view about timing after it knows how many comments it's received and after it takes a look at the content of the comments themselves.
Tatel?
No.
Judge Rogers, any additional questions?
No, thank you.
Cut
Thank
you
you.
off, but I think we have your argument.
Thank you, Your Honor.
Thank you. Perhaps 2 minutes for Mr. Kirkpatrick.
Thank you, Your Honor. I only have two things to say. The first is this current comment period, it is not a rulemaking. It moves us no closer to a rulemaking because there's no commitment to do a rulemaking. They're studying if and whether to do a rulemaking. My second point is that on the argument that it is somehow discretionary for the agency to decide whether a rule is necessary, Congress knew the FAA's position on this at the time of enactment. The agency had just come out in July of 2018 with a response to a petition for rulemaking on this subject and said the agency doesn't think minimum seat size regulations are necessary for safety. And just 3 months later, Congress essentially overruled that and said, no, we think it is necessary and we are requiring a rule.
Well,
Again,
all we have to go on in terms of the mandamus question here is the words of the statute, right? We're not going to look behind those. I mean, maybe we would if this was a Chevron case, assuming Chevron even exists anymore. But at this stage, where your burden is to show that you're clear and indisputable grounds for relief, I don't see how we can go beyond the plain language of the statute.
well, Your Honor, we think that we should prevail under the plain language.
Okay, then let me ask you this. Going back to the discussion you and I had earlier, assume here, I'll give you your side credit. Assume there's two plausible interpretations of the statute, the agency's and yours, and even assume that yours is more plausible than theirs, but theirs is still plausible. That is that the language necessary for safety excuses them from issuing regulation now. Let's just assume, because you agreed with me before that was at least plausible, and yours is more plausible. You still have to show that you're clearly and indisputably entitled to relief. And can you make that argument? Go ahead and make that argument for us. Explain to us how, given the fact that the agency's interpretation, though less plausible, is still plausible, how can you be clearly and indisputably entitled to relief? What's the argument?
Three arguments.
We just need one. Go ahead.
Okay, well, I'd like to give the
okay,
three,
you can have three.
But one is that it is a more natural reading to say that safety is the criteria.
Okay, but more natural doesn't answer the question. That's just saying more plausible.
All right. The second would be that it's absurd to say that there might be no minimum. We know, just as a matter of common sense and basic physics, that
excuse me, but the agency hasn't said there won't be. The agency has said it's unlikely to go below a certain level, and presumably, if it does, they'll issue a regulation.
But right now, there is no regulation
right.
On these dimensions.
But is there any current threat to safety?
Yes.
There is?
Yes.
I thought even you agreed there wasn't at the current level, at the current dimensions.
No, we actually think that the agency is wrong with respect to the current dimensions, because the one simulation that they did using current seat sizes, the population of volunteers who participated in the simulation do not have the same demographics as the flying public.
But
you mean they're not fat?
Exactly. There were no obese people. There were no people over 60, nobody with a disability.
Wait a minute.
No
People over
children.
60 aren't all fat.
Let me get you on happier ground, maybe, but maybe not, because I think what the FAA said is the issue with evacuation speed is not going to be how fast people can get out of their seats. The issue is that line that forms in the middle aisle, and we've all gotten off of an airplane, not an emergency, thank goodness. And that line is what is slow. And so whether or not it takes someone 5 seconds to get out of their seat or 25 seconds to get out of their seat, the FAA is saying there's nowhere to go. The line is not moving fast.
Well, we think the studies are deficient, and the Office of Inspector General pointed out some of the missing data and invalid assumptions that underlie some of those studies. But again, we accept the risk that the minimum seat sizes established in a proper rulemaking could essentially codify the status quo.
So you keep saying that, but the statute says that are necessary. Usually, if the status quo is perfectly fine, then a regulation is not necessary.
but there is no regulation at all right now. So there is nothing to stop the
most of life does not have regulations. At least it used to be that way. So usually I think agencies only do regulations when there's a problem to fix.
And the FAA decided there was not a problem to fix. Congress essentially overruled them and said, we want a minimum seat dimension regulation.
Judge Tatel?
No, I'm finished.
Judge Rogers, anything else?
Yeah.
Thank you.
Thank
The
you.
case is submitted.
And
Yes, Judge?
hi, do you see a video of me?
I no longer do, Judge. I can send you a request. Perfect. I saw you briefly for 1 second. I see you again, Judge.
Where? I don't see me, and I'm looking on the screen.
You are visible in the courtroom, Judge.
Judge, you have been visible for the
Good.
first
Glad
argument.
to hear that. So I haven't certainly, I saw myself earlier when I logged on with Ann, but not now. In any event, if everybody else sees me, that's fine.
We do see you, Judge.
I see you, Judge Tatel.
Case number 21-5258. Bradley S. Waterman, appellant versus Internal Revenue Service. Mr. Vladek for the appellant, Ms. Aveda for the appellee.
Good morning, Your Honors, and may it please the court. The question before the court today is whether the deliberative process privilege shields memos laying out the factual basis for allegations of misconduct against Mr. Waterman. And the answer to that question is plainly no. This case is unusual because the IRS seems to be at odds with itself. The IRS argues that disclosure of the factual basis of the allegations could shield reporting of misconduct, even though none of the IRS's declarations mention any specific harm to the deliberative process privilege, let alone the chilling effect argument made in the IRS's brief. Now, this absence may reflect the fact that the Office of Professional Responsibility, OPR, as I'm going to refer to it, disagrees. Its practice is to provide practitioners a full and fair opportunity to respond to misconduct allegations to ensure that there's a fair basis for its decisions.
What is this? I was going to ask you about that because you make that argument in your brief. What do you point to? What regulation or agency directive says that? As I understand it, your position is that had they proceeded against Mr. Waterman, they would have disclosed these 4 documents, right?
That is correct.
Okay. What do I look at in the record to find where the agency has made it clear?
Yes, I think it's 1060, 31 CFR 1060, and then there is a second regulation if in the event that there was a disciplinary provision, I believe it's 10.71 through 74, which gives him a discovery right. But the rule says a proceeding will not be instituted under this section unless the proposed respondent previously has been advised in writing of the law, facts, and conduct warranting such action.
Well, that doesn't say previously advised of the law and facts. Doesn't say that you'll get these 4 documents, does it?
Your Honor, the other point that we're trying to make, however, is that the Office of Professional Responsibility, after the 2018 district court ruling against Mr. Waterman, issued an alert that says that Mr. Waterman brought this case, the FOIA case, to challenge the denial of, quote, specific information regarding the allegations. That's referring to the 3 affidavits or declarations that the IRS submitted to this case.
Well, wait, let's just look, you're talking about this alert, right?
Yes.
Okay, so I understood, tell me if this is wrong. I understood that to say that here, like in Waterman's case, if this alert had existed, he would have gotten earlier the same information he got in the September 10th letter. It doesn't say anything about whether he would have gotten these four, any underlying documents. Just whatever was in the September 10th letter that told him the proceedings were closed, he would have gotten at an earlier stage. Am I reading it correctly?
No, Your Honor, you're not. By the time this alert was issued, the IRS had already issued what's called the explanation, which is a fact-free sort of indictment of my client. But what OPR is saying is the failure to allow him to get the factual basis of these allegations was, quote, inconsistent with its OPR's commitment to provide practitioners a full and fair opportunity to respond to the allegations. And let's just go back to the insight of Trombley and Iqbal. If you're trying to resolve a motion to dismiss on Rule 12b6 grounds, you can't possibly evaluate the allegations without the underlying factual, the factual basis for them. And that is what OPR is saying. If not, OPR becomes a star chamber. It just relies solely on IRS documents.
That is, to a degree, the government's argument here is that their ultimate decision depended on the facts. And according to the Vaughan Index, the documents you want are documents that describe the facts that were necessary for them to make their opinion.
Yes, Your Honor, but let's go back to the IRS's declarations in this case. There is not a syllable in either the Rollins declaration or in the Vaughan Index that points to any specific harm under the deliberative process privilege. The argument about...
Do we require that?
I believe you do.
I thought our case law basically said that, if it's facts, it has to be turned over. But if it's sort of curated facts by an employee who's putting together a case, then it's covered by the deliberative process privilege.
My point, Your Honor, is there's nothing in any of the affidavits or declarations that talks about harm under the deliberative process, let alone alludes to this chilling effect. And this court just recently, and I'm going to mispronounce the name.
Right, I can't pronounce it.
But in the Machado Amatis case, I believe, and pardon yes, but it was the same question in that case. And the court said, look, unless there's some substance to this, the agency loses. The agency bears the burden of providing the essential elements of the claim. And here in Machado, the court said the agency's affidavit explained in full why there would be chilling effect. There's nothing in the record that goes to that. And going back to the OPR bulletin or alert, here's our problem. We have been throwing down the gauntlet ever since this case started to say that Mr. Waterman is the only practitioner who's ever been deprived access to the factual allegations that underlie the misconduct referral. It just, to go back to Iqbal Trombley, you cannot assess bare bones allegations without some understanding.
Why do you think those facts were put into a document?
There's no question that Mr. Marchetti and Ms. Kelly thought that Mr. Waterman had engaged in misconduct. And, I don't doubt their good faith. I work in the government,
Why do you think they wrote those documents? Why do you think they put those facts in those documents?
To persuade, I'm certain that they wrote those facts to persuade the Office of Professional Responsibility to initiate a disciplinary action.
I mean, so then to quote Ancient Coin, which is itself referring to Maypother, which you, of course, know Maypother very well, an exercise of judgment in extracting pertinent material from a vast number of documents for the benefit of an official called upon to take discretionary action. That's when they're protected.
Yeah, but that's not the case here. there was, for Ms. Kelly's declaration, there was no vast universe of facts. Her declaration dealt with a single telephone call between her and Mr. Waterman. And she made a contemporaneous report of that.
What about the Marchetti?
Marchetti, the one index says he compiled actions and statements by Mr. Waterman. That is what he did.
And is it in the public record how many pages that compilation was?
There is, I believe it was 9 pages.
And how many months or years did Marchetti interact with Mr. Waterman?
Oh, several years, Your Honor.
So that would be, if you were listing all the facts of those interactions, longer than 9 pages.
I'm sorry, listing all of them? Yes, sir. Yes, that is true.
If Marchetti were to list all of his interactions with Waterman, that document would be a lot longer than 9 pages.
Undoubtedly correct, Your Honor. That is true. But the question here is, what did he put down? And the declaration of Ms. Rollins says, what did he put down? He put down the actions and statements of Mr.
No, actually, it says, this. I wanted to follow up on this question with you. It actually says he recorded in his memorandum actions and statements that Marchetti believed made the referral appropriate. So he made the referral appropriate. So I've looked at the document. How do I know you haven't, but what does a court do with a situation like this? Okay, we've got the document in front of us. We've got the affidavit, which says a description of actions and statements, quote, that Marchetti believed made it appropriate. So what do we do with that? I mean, I can look at it and let's assume to me that it looks comprehensive, but I have a sworn statement by the agency that it isn't, that it's selected. What do we do with that?
Again, it's the agency's burden to prove an essential element of the exemption. And here there is nothing in any of the IRS filings that says that the release of these documents to allow Mr. Waterman to defend himself would cause some kind of chilling effect. And remember, in some ways, I think this argument is somewhat demeaning to IRS staff. The IRS staff are under an obligation by regulation to report any suspicious misconduct. When I worked in the government, if someone, had suspicious conduct, they would have reported it and they would not have said, oh, gee, I don't want to report this because it might become public. What I really want to know from the IRS is, what is OPR's real practice? Because if you read the alert the way I do, what they're saying is the failure of the IRS to give access to Mr. Waterman about these factual memos was not consistent with their practice. There is no manual about how OPR goes about its business. But we are really concerned that he is the only one who has not been able to at least understand the factual basis for if you look at the explanation, these are very sharply worded allegations without any underlying factual predicate for them. I realize my time is well over, but I'm happy to
Judge
answer.
Tatel, any additional questions? Judge Rogers, anything else?
No, thank you.
Give you 2 minutes.
Okay, thank you very much.
Thank you.
Good morning, Your Honors. May it please the Court. Julia Vetta for the IRS. I want first to answer a question posed by Judge Tatel, which is whether Waterman, under the new OPR letter writing procedure, would have received the same information as he did under the previous regime. My opposing counsel has represented that the file would have been effectively magically revealed and all claims of privilege would have dropped under the new procedure in OPR, and nothing in the alert reveals that to be the case. There is no guarantee that a request made under the new procedure would result in any different outcome from a result made under the previous procedure. Previous procedure.
Wait, can you just back off? So, as I understand the alert, what you're telling me is that all it says is that Waterman would have gotten what he got in the letter earlier, correct?
Possibly.
What do you mean possibly?
There may be other 6103 protections that aren't triggered in a FOIA request that may have been applicable at that time. There has since been a waiver of a number of 6103.
You mean possibly he would have gotten more than he got? Or possibly he would have gotten less than he got?
He would not have, in either event, he would not have received anything that the IRS would hold back under the deliberative process privilege, a separate question from any changes in what might have been disclosed under 6103.
Okay, but setting aside the alert, Mr. Vladek's point is that had OPR, instead of closing the case, proceeded against Mr. Waterman, he would have had access to these documents.
He would have had access, Your Honor, to the factual allegations made against him. Not necessarily in the form made in these documents. What we don't know is whether the ultimate allegations made against him,
the letter, is it September 10th? The letter, oh no, I'm sorry. When he asked the agency for these documents, before he filed his FOIA, the agency said, well, we can't give them to you because the proceedings are now closed, correct?
Correct.
And they cited a statute for that.
6103.
Well, doesn't that suggest that if the proceedings are no longer closed, that is, if they're proceeding against him, he could have the documents?
He could have received, so that goes to the change in procedure. The previous procedure in OPR advised a practitioner who had been referred to OPR that claims had been made against you, but we have decided not to proceed against you, and we have closed your file. The provision of 6103 cited by OPR when it declined to share his file with him was the provision that protected closed files from disclosure. That provision, which we cite in our brief, only permits the disclosure of files in an active proceeding to assist in a practitioner's defense. So when they close the file,
that's his whole point. His whole point that had OPR proceeded against Waterman instead of closing, have had access to these documents.
No, he would have had access to what he eventually received under his FOIA request. As it were, as it was under the previous. Can you cite is there an IRS regulation that governs what people are entitled to who OPR proceeds against? Well, Circular 230 prescribes the procedure when a complaint is filed against a practitioner before the IRS and the discovery rights that they have during an OPR proceeding.
All right, and what does that say about these? What does that say that would help us?
Well, it allows you to, it certainly allows you to access the factual substance of the allegations made against you. That's actually going to be apparent in the complaint.
How can someone defend against a factual allegation unless they see the underlying analysis of the agency that supports that?
Well, Your Honor, you have no doubt witnessed many a discovery dispute where parties alleged that the pre-decisional deliberative documents that led to those allegations were protected by this same privilege, and that will arise even in a Circular 230 proceeding.
Can you cite a case for that?
I offhand, no, I can't name a discovery dispute, but my point is this. The availability of discovery and evidentiary procedures in Circular 230 has its own governing structure. It's not quite the federal rules of evidence, but in the past, people complained about Circular 230s being more, I believe my colleague called it a star chamber. It is not like that now. There are rules and you can access the facts against you. However, what you cannot access under the new OPR procedure, making requests for your file before they close it, is the same information that is protected in a FOIA request, which is the pre-decisional deliberative process. For example, if these line-level employees decided to refer Mr. Waterman for misconduct for, let's say, 3 different incidences of wrongdoing, and OPR chose to proceed only with 1, the allegations that were not advanced in the complaint would be withheld on relevance grounds as well, but certainly is pre-decisional and deliberate. And that's where the concern comes in with the chilling effect. Of course, employees have a duty to do their jobs, but they also have the protection of not having their thought processes laid open for public scrutiny, particularly in cases where no further action is taken based on their recommendations.
Oh, and we may be talking past each other. Your particularly sentence, the phrase that you added on, I get that. Okay, I get that. But the point is that these documents would have been available and OPR proceeded against. And
I don't believe that
therefore,
is correct, Your Honor. I believe they would have been protected by a claim of privilege, which would have then, I guess, been subject to litigation.
okay, if it's okay, I would like you, after oral argument, to cite for us the best authority you have for that. Okay? If that's
Beg your
okay.
pardon?
Of
course.
We'd
Okay.
like the best authority on the proposition that.
Yeah, on the proposition that the deliberative process privilege or some form of it would operate to deny Waterman access to these documents, even if OPR had proceeded against them. Okay. So let me ask you a different question. Okay. So the Rollins Declaration says, I cited this to Mr. Black. It says that Marchetti, that these are facts that he believed made the referral appropriate, right?
Yes.
Okay. I've looked at the Marchetti memo. We know it's, I think the declaration says it's 9 pages, so I can say that. To me, it looks like a chronology. So what do I do as a judge reviewing this thing? I have an agency declaration that says it's selective. But I look at the document, it doesn't look selective at all. It looks like, to me, exactly the kind of document that the chronology that was in this case called Men Other, whatever the case is, the Kurt Waldheim case. Looks just like that.
I think that the presentation of information in chronological order does not imply that there was a lack of deliberation in the selection of that information. And as Your Honor yourself noted earlier, this was information that Mr. Marchetti selected out of the universe of his dealings with Mr. Waterman.
But the universe of Waterman's dealings, but why would it be such a broad, wouldn't it just be the universe of this, of the case for which he's charged?
Well, and that therein lies the rub, because what he's doing is he's creating a persuasive case. His selection of the facts is based on his belief.
But look, if I hadn't looked at the document, I would say, okay, I get it. We have a sworn declaration. But like the district court, I went and looked at it. So, and I'm asking, what do I do when, and it's the agency's burden here. The agency has the burden of defending the application of the deliberative process privilege. So if I have a sentence in a declaration that says these are facts that he, quote, believed made it appropriate, but I look at the document and it doesn't look that way, wouldn't I say, well, I don't think the agency satisfied its burden of proof. It hasn't explained to me. Sure, the sentence that's in the declaration says that Marchetti believed made the referral appropriate. That's conclusory now that I've seen the affidavit. He doesn't say in what respect. What's he left out? What kinds of decisions did he make? And when it's the agency's burden, aren't I entitled to ask that question?
And this is where we have the benefit of the district judge's in-camera review.
Well, I reviewed it too, and we're de novo.
Yes, but what?
So what?
District judge's views are helpful
excuse me,
here.
but
Because he says he did not uphold the IRS's invocation of Exemption 5 and the deliberative process privilege because of the nature of the factual material contained within the records, but instead because of how those documents were prepared and for what purpose. And as your honors have observed.
But the district court had the same thing I did. The district court is basically describing the Rollins Declaration. And what I'm trying to get some help on from is, what I'm saying to you is that, at least as one of the judges who's looking at this case, I'm worried about your burden of proof. And what's your best answer to my concern here, where I have an affidavit that in conclusory form says it's selective. When I look at the document, it doesn't look that way. What do I do? That's my question. I'm not arguing with you about it. I'm asking you for your thoughts about how a reviewing court is supposed to think about it.
Well, we have to look to the purpose of the document, and we have to look to what Mr. Marchetti told Ms. Rollins when she made her declaration, which was, yes, I put that together because I was building a case, because I was advocating. And this is a distinct, a different type of list making from a sort of broad net catch-all investigation where you are listing all of the information you find, or you're possibly making relevance determinations. He's going a step beyond that. This isn't merely everything that's relevant. This is what he thinks are his best facts.
Yeah, but all right. So when I said to you that I looked at the document and it just was a chronological list, your response was, well, chronology can be an important way to present the facts. But in the Waldheim case, I'm calling it that because I can't pronounce the name of the case, but you know which one I mean.
Yes.
We said it was a quote, inventory presented in chronological order containing a comprehensive collection of the essential facts.
A comprehensive collection of the essential facts. That's right, Your Honor.
Yeah.
And this is different from a comprehensive collection of everything that Waterman did. The Waldheim chronology was a comprehensive collection of everything that Waldheim did during his military service, and that was why the court released it after an in-camera review had so determined. Here, our in-camera review has made a different determination, which is that this involved thought. This involved an attempt to persuade. This involved beliefs that these were the best facts to build a case that this practitioner had committed misconduct before the IRS. Right. It's not comprehensive and it's not exhaustive. There are many, many instances of non-misconduct that are not on that list.
But how do I know that? I mean, I've looked at the document. Shouldn't we say to the agency, well, let's go on. You and I have talked about this for a while. Let's take a look at let's talk about the Kelly memo. The Rollins Declaration says about that it says sets forth part of the facts that made it appropriate, right? So I've read the Kelly memo. It looks to me like a straightforward summary of a telephone call. I mean, how do I know what she didn't put in there? How do I know from looking at that she was selective, since Rollins didn't tell me? She just stated conclusorily that that's what she did, but she doesn't tell me how.
What you know she didn't put in there is information not necessary to build the case against Waterman, because that's the purpose for which she wrote that memo.
How do I know that?
I believe that you don't know it from the Rollins Declaration.
Right, that's my whole point about the burden of proof.
Well, but
that's exactly my point.
Must a declaration state, define the universe of facts from which a piece of advocacy is drawn in order for that piece of advocacy to be deliberative?
That's exactly why I'm asking you the question. I don't know the answer to that. I'm asking you for some guidance about this. I don't.
Well, we
think it's tricky because in most FOIA cases, we don't go look at the record. But here they were so short, I went and got them and read them. So now I face this dilemma.
It's not simply the record of, for example, the investigation of Mr. Waterman's potential wrongdoing, because there was no such investigation. The investigation was referred and OPR said, we're not proceeding with this. There would be a record of an investigation had there been one. These pre-decisional deliberative documents are how you would get to that investigation. And that's the goal of those documents, and that's why they were prepared. There will not be in any declaration at this phase in the proceeding a contextualization of those allegations within the universe of a practitioner's good conduct. And it wouldn't make sense for there to be. It wouldn't make sense for Rollins or for Marchetti or Kelly in briefing out the facts that they believe support a referral for misconduct to list off all of the many, many years of Waterman's practice and all of their voluminous interactions with him during which he committed no misconduct. That's not how that part of their case for misconduct.
Kelly and Marchetti had an opinion about what OPR should do, correct?
They did.
What was their opinion?
Their opinion was that OPR should investigate Mr. Waterman for potential misconduct.
that opinion was their point of view, correct?
It was indeed.
And did these two memos from Marchetti and Kelly reflect that point of view?
That is our position, and that is.
And if they did reflect that point of view, they're protected under the Maypother-Waldheim case because the chronology in that case did not reflect a point of view. Quote, exactly. The chronology reflects no point of view. So exactly. Let me try a version of Judge Tatel's question. I'm not going to speak for him. I think you have a good chance of winning if these documents, Marchetti memo and the Kelly memo, reflect Marchetti and Kelly's point of view about what OPR should do. How do we know that they reflect Marchetti and Kelly's point of view?
We know from the Rollins declaration, she has confirmed with both Marchetti and Kelly that they wrote these memoranda specifically with the intent of making an OPR referral and having selected the facts to support that referral. We know the purpose for which those documents were prepared.
And can we also infer that purpose absent the declaration just by looking at the documents?
We do not suggest that that is necessary on these facts. We're just looking at the Vaughn Index and the declarations. We are not urging an in-camera review of the documents to make a holding here. Although
I understand that, but if I have reviewed them in camera, I don't want you to say anything that's not public. What is your best argument for how I can infer from that 9-page, 1-page, that those documents reflect Marchetti and Kelly's point of view that OPR should engage in an enforcement action?
As Chris has noted, this came during an extensive interaction between Waterman and the IRS. There were not multiple instances of, there were not multiple potential referrals. There was one instance where Marchetti and Kelly said, something's going on here, and they put their hands together. The rest of the time, as you noted before, years and years and years of documents going back and forth, interactions between the agency and the practitioner. Those were not documented here with the purpose of creating a referral or supporting a referral to OPR. And that's key because you are winnowing this universe of facts down to the facts that you believe make your case.
Again, to quote Maypother, you think they betray the occasion that gave rise to its compilation.
Precisely.
And you think it would be inaccurate to say no known datum in the selected category has been omitted.
Beg your pardon.
Well, that's all right. I have my answer, but Tatel, do you have more?
Yeah, I do. I want to, if you want to continue pursuing that, I'm going to change the subject.
Please do.
So I know this is a FOIA case, and it's not about the legitimacy of the September 10 letter. I have to ask you about this, which seems to me to be deeply unfair. This letter says to Waterman, we're not going to charge you, but the information, we're going to retain it in our files because it might be used against you later if you get in any more trouble. You're welcome to respond, it says, but that won't affect, we won't consider it at this point. And then it says you should modify your behavior accordingly. I mean, explain to me why the IRS thinks that's fair to someone. You're basically saying we're not charging you, but we're keeping all of the evidence we have against you on file. It can be used against you later. And by the way, I don't have the language right in front of me. You should adjust your behavior accordingly. In other words, I mean, how can a federal agency tell someone?
My first response, Your Honor, is that you've identified the reason why they needed to change the procedure.
Well, this doesn't change the procedure. Under the new procedure, it'll be exactly the same. The only difference, as I understand it, under the new procedure, is that Waterman earlier, before they closed it, would have been told essentially what was in the September 10 letter. It doesn't change this at all, right?
He would have received. Okay, so here's how the new procedure. Yeah. The old procedure, they would issue that letter. Says
you're talking about the September 10 letter?
The September.
Do I have the wrong date?
September 10th is the Marchetti memo.
He only got one letter. What's the date of the letter? I'm sorry. It's what's the date of the letter
Oh, it's
that,
also September 10th. You're correct. Oh, so,
Okay.
so the Marchetti memo and the OPR letter are precisely a year apart. Yes, the September.
I'm not
10th,
talking about
2014
those.
letter.
I'm only talking about the letter that Waterman got.
Yes.
Do I misread that letter?
No, you
By the
do
way, we're
not.
not charging you, but you better adjust your behavior. I mean,
Did receive that.
I mean, that's like saying someone's indicted for robbing a bank, and they drop the charges against them, but they say, okay, we're dropping the charges, we're keeping all the evidence. If you get in trouble again, we're going to use it against you, but don't rob any more banks. I mean, how does that conform with even the simplest concepts of due process?
I think evidence of past wrongdoing is frequently relevant in subsequent proceedings, and the agency is under no obligation to destroy its records just because an investigation is not pursued. However,
What is the
Also
misconduct?
say, excuse me, in the letter,
Yes,
no,
that's. what
destroying it, they
Judge
said, you're welcome to file something and respond, but we won't consider it.
and that's the change.
What's the change?
Now, that letter does not promptly close the file. That letter is issued when a practitioner is notified that a referral was made, but an investigation.
Can I see if I
will not be
understand the
pursued.
change correctly? Because it sounds like a slight improvement, but not enough of improvement to alleviate the kinds of concerns that Judge Tatel is airing that I share. In the old regime, they would say to someone like Mr. Waterman, there's an allegation against you, period. In the new regime, they'll say there's an allegation against you, and we will tell you what that allegation is. But even in the new regime, although we will tell you what the allegation is, we will not tell you the facts that support that allegation. Am I correct that that's the new regime?
The new regime, so both the old and the new regime do come with a summary of the allegation. So it's not a total mystery. But the factual basis for the allegations is not revealed absent an inquiry. You're not going to be presented with them in your first communication with OPR.
Right.
What OPR provides you now is the opportunity to request those and to request as much of your file as is unprivileged and can be disclosed to you. And once you receive that, and you will then have a sense of what is being referred.
Would Waterman get anything more under the new procedure than he got in the September 10 letter?
He
How do
would
we know that?
receive what he got in response to his FOIA request, at a minimum. Unless
Where does it
Isn't that also a maximum? I thought you said.
Yeah, so but there, what I
He would
don't
not
know based
receive-
on this record is what other privileges might be implicated.
In
But
the
because
new regime, he would not receive anything more than he currently today has, correct?
I believe that's correct. But he would receive it on first request. And he would not have his first request rebuffed because his file was closed and then need to file a second FOIA request.
So
Here's
your
what the, wait,
position is under the, go ahead, Judge Tatel.
no, you go ahead. I didn't mean to interrupt.
No, please continue.
I was just going to ask you, I'm looking at the alert. Okay. OPR now sends a letter to the practitioner advising him of the issues presented. That's all it says. And then it says, when appropriate, it sends a second letter with the soft letter. It sounds to me like, I mean, you can explain this to me, but the way I understand this, Waterman, once they decided to investigate him, he would get what he got in the September 10 letter. And sure, he could ask for more information. The agency would probably deny it, but all he would get is what's in the September 10 letter. And then, so that's my understanding number one. My understanding number two is that even under the new alert, if the agency decides not to proceed against a lawyer, that lawyer will get exactly what the September 10 letter was.
I don't believe that.
In other words, we're going to keep it. Oh, they won't be told any longer that it'll be kept on file? And they won't be told any longer that they can respond, but we won't consider it? And they won't be told any longer that they should adjust their behavior accordingly?
We don't know from this alert how the text of the letter has changed. And we do know that there is now an opportunity to request the file and receive it without making a separate FOIA request. That's the material distinction here. If you receive this letter that advises you of the issues presented in the matter under investigation, gives the practitioner an opportunity to comment, you can now add to your file. And you can say, these allegations have been made against me. Here are my potential defenses to this. And I believe for example, in this case, the potential misconduct of which Marchetti suspected Waterman involved unreasonable delay. An unreasonable delay is an allegation that is not a mystery. I mean, for someone who has been a part of this process and knows how long it's taken, he can offer defenses and add information to his file in response. And this new process creates an opportunity for him to do exactly that. So he can respond and say, please provide me with what you've got on these allegations. Yes, I want to see my file. He gets the file, which resembles precisely the FOIA disclosure, and he is able to comment. Mm-hmm. And only thereafter do they close his case. And it says this two-letter process gives a practitioner who wants to know more about the allegations an opportunity to make a request before the OPR closes the matter, thus fitting within the framework of the 6103 provision. It waives no privilege. It doesn't change the contours of the file other than to remove this one block to disclosure under section 6103 that the previous letter imposed.
Ms. Aveda, I know that Judge Rogers has attempted a question. Judge Rogers?
Yes, thank you, Judge Walker. My only concern here is, initially I understood the IRS to be piggybacking on sort of criminal procedures. But it's become clearer and clearer that that's not what's happening here, that this is something quite different. And I understand that I originally thought, well, he knows the essential allegations, like, it's alleged that undue delay. Well, in what respect? With regard to what? With regard to what element of the case? I mean, he's been practicing for years. Just think of how he could respond. And he may have wonderful reasons for those delays, but they may be irrelevant to what the agency was considering. So I guess the question still in my mind is, I understand you push back and you say, well, now you get two letters. And I thought, yeah, but if you don't know what it is and you've been practicing there for years, and apparently no complaint has been filed before, so how is he supposed to change his procedures? All right, he's supposed to never violate a rule on the agency about your opposition is due within 30 days or something like that. It's just not clear. And so I guess what we're concerned about is, so far as I know, if a practitioner's sole practice is in this particular area, and he's trying to clear his record, and he gets this statement from the agency, so presumably in any future matter he's involved in, somebody in the agency is going to note that record, even though there are no charges. But I just think this is entirely different from a criminal procedure where you're not arguing that you have to be able to determine beyond a reasonable doubt that he's violated something, much less that the prosecutor has to make representations that it has the evidence that could be its burden of proof. So I just think this is so different, and the agency has a right to set up its rules, but if it's going to have some sort of broad new approach that anyone who files more than 30 days late is subject to a potential complaint, then it's quite a different agency procedure. And that's what's unsettling about this matter. And we're trying, I think our questions have just been trying to give you the best opportunity to assure us that, this is not a situation where somebody has a gripe against the attorney. He may have had bad relations with some client, There may be an explanation as to why he was unable to respond, but what does he do? File sort of a case history of all his proceedings over decades? That's what's troubling.
Well, so the most immediate response to that, Your Honor, is that the information he's received here is that he is not being investigated. The claim against him is not being.
But this can be used against him in the future, and in the meantime, he ought to change his procedures. That's all.
And that wording is unfortunate, but it does not place him at a disadvantage in a subsequent proceeding where those allegations against him will be fleshed out in detail if they are relied on by the agency.
Well, he risked having another complaint filed against him. And as I understand it, part of his concern is his reputation before the agency. He comes to the agency with sort of an asterisk by his name. In any event, thank you, counsel, for your efforts to assure us that the agency understands unfairness and its new procedures will
Well, let me just follow up.
Our concerns. And Judge Tatel.
I just want to follow up on Judge Rogers' question. So is this September 10 letter public? Is it on the agency's website?
I would not be surprised if it were, but I can't answer that to a certainty.
You see why I ask? I mean, suppose I'm a client looking for counsel before the IRS, and I know about this.
Against him? No. I don't believe that decisions not to proceed with investigations are published based on the individual's name.
The letter.
Could I obtain it through FOIA?
I do not know. I could not state right here that it might not be subject to some withholding privilege. I do know that reputational harm, as he is threatened with by an investigation that was never pursued against him, is effectively of his own making, since he has publicized the documents through this case.
Well, that's why I ask whether the documents. That's why I ask whether they're available on the FOIA. I mean, if I were a corporation looking for counsel in tax case, I might say to the IRS, I want to see. I don't know what you call these letters, but I want to see these letters. And if I saw a letter, if I was thinking of hiring Mr. Waterman, and I saw a letter that said,
allegations were made against you, but not
these allegations have been, and it said that he's been told to, quote, modify his future conduct accordingly, based on allegations he's never seen that the agency hasn't pursued. I wouldn't hire the guy.
On the record before this court, I regret that language on behalf of the agency.
I wouldn't hire.
But the letter itself does not put him in any legal jeopardy. He has not been accused. He has not been subject to an investigation, and no complaint has been filed against him.
Yeah.
I know you say it's unfortunate, but it's a fact of life in his case.
Yes, Your Honor.
The agency sent him the letter, and now the burden is on him to do something. Okay, thank you, counsel.
But before you go, Ms. Vetta, if you could, within say the next 3 days, and the court would be grateful if Mr. Vladeck could do the same. Let us know of the rules and regulations that govern what Mr. Waterman would have received from the IRS if the OPR had proceeded against him. Thank you. Mr. Vladeck.
No doubt my time has expired.
You can respond to.
Judge Walker, our opening brief does go through the various steps that would have been taken had there been a disciplinary hearing, and I think the answer to your question is in our opening brief, but we will certainly provide that.
Yes. So if we want a sneak preview of what will be filed in 3 days, where in your opening brief would we?
I was just searching for it.
That's okay.
Yeah,
we'll find out in 3 days.
I have a lot to cover, and I realize
we'll give you. You can have more than the minute and a half that's left.
Okay.
I think that your opposing counsel, we gave 25 minutes.
Thanks. I just want to quote from the other side's brief. in response to a question Judge Tatel asked, and it says this on page 40 of the brief, quote, had the Office of Professional Responsibility chosen to take action against Waterman, he would have been apprised of the facts and the allegations against him. So there's no question that if there had been a disciplinary proceeding, he would have gotten the facts that were, laid out in the Marchetti and the Kelly memoranda. Let me also try to explain why I think the bulletin is more important than perhaps the IRS has suggested. What the bulletin says, and this is on JA 175, at the end of the second paragraph, that Mr. Waterman went to court with a FOIA request. But there, the IRS continued to deny specific information regarding the allegations. Now, that is plainly a reference to the allegations that are contained in the Marchetti, Kelly, and Brown memoranda. And the OPR then goes on and says that the district court's ruling, quote, is inconsistent with its commitment to provide practitioners a full and fair opportunity to respond to allegations. Now, again, I don't know, and I cannot represent that Mr. Waterman is the only one who has faced this kind of allegation of misconduct without having access to the factual record. But there is, again, likely harm is an essential element of the IRS's case. They have to claim privilege and show privilege. And once again, I just want to underscore, there is absolutely nothing in the declarations that goes to this chilling harm argument. And in fact, it doesn't really make sense because here, Mr. Marchetti and Ms. Kelly filed this referral for one reason alone, which was to ensure that there was an investigation and a discipline hearing for Mr. Waterman.
So that, Mr. Vodek, seems to resolve the FOIA question against you, which, we've been talking for the last 10 minutes or so about whether what the IRS did with its letter to Mr. Waterman was fair or outrageous. But the inquiry into FOIA, and I can't remember the exact phrasing that you just used, but the inquiry into FOIA for deliberative process seems to be, were the facts in the document compiled and curated for the purpose of advising the agency of what to do? And that seems to be what you just said the purpose was. Well,
advising, yes, any referral advises the OPR to investigate.
If I asked my clerk, who should win this case, and I said, just do a document. I just want to know and he said you should win. And I said, well, just do a memo for me that says all the facts that support what Mr. Waterman winning. That would be a chronology, and I said put them in chronological order. That would be a chronology of facts, but it would be with the purpose of advising me how to make a decision that seems to be textbook deliberative process. And
having argued Mapother, your question to me was, you were channeling Judge Buckley, who was presiding, and he asked the same question. But once again, let's go back to Mapother. First of all, the government ultimately released the entire report. Why did it release the entire report? Because the chronology section, which it said should be released, was the roadmap to all of Waldheim's misgivings.
Maybe that means that, that means that Mapother's ultimate decision was in conflict with itself.
No, Your Honor, because the chronology section, this court ordered disclosed.
Right, I know. I mean, maybe that part of the court's decision was in conflict with the other part of the court's decision, what they said should not be disclosed.
I don't think so, Your Honor. I mean, what the court said is there's no valence to this. These are just facts. These are just facts. They're assembled by people like Ms. Kelly and Mr. Marchetti.
The court said that in the chronology, the court said no fact was left out. That is clearly not the case here, because if no fact had been left out of Mr. Marchetti's interactions with Mr. Waterman, that document would not have been 9 pages. It would have been 109 pages.
Well, that is true, Your Honor. That is a difference. and I have not looked at the records, but to the extent there's a chronology of what Ms. Kelly and Ms. Marchetti think was wrong, why isn't that just like the chronology section in Mapother, which was required to be released?
Because in this case, it reflects a point of view. Mapother said the chronology reflected no point of view. In this case, a datum has been omitted. In Mapother, the chronology was a chronology where no known datum in the selected categories had been omitted. In this case, the chronology betrays the occasion that gave rise to the compilation. In Mapother, the chronology in no way betrayed the occasion that gave rise to the compilation.
Just put again the IRS's brief. Rather, and now I'm on page 33, rather, the facts were carefully selected with one purpose in mind, to support allegations that Waterman had violated certain provisions of Section 230. There is nothing in these declarations that say anything about chilling effect. There's nothing there at all. The only reference to the deliberative process privilege is in Ms. Herring's declaration, where she thinks that maybe this is a work product.
And maybe that's the test we should apply. We should just ask ourselves whether it would have chilling effect. Of course, I mean, that is one of the main purposes behind the privilege. But of the three differences I drew between the chronology in the Waldheim report and what is publicly known about the Marchetti and Kelly memos, do you disagree with any of those three differences? Or maybe a better way to phrase it, do you agree that these memos are different than the chronology in the Waldheim report in at least those three ways?
I don't think so, Your Honor. And let me just take a step back. The point of the chronology was to lay out where Waldheim was during the Second World War. And from that chronology, any reasonable historian could have deduced everything else in the report. That is why the government ultimately decided to release the entire report. And here, what you have is a selective, you have a selective release. You have the explanation that releases all the allegations, paints my client in a very poor light. Everyone in the IRS knows about this. And once the alert was published, everybody else could figure this out, right? So there's no hiding from this for my client.
But it is for that reason. Let me just go through each three. You tell me if you disagree. It is for that reason that the memos in this case reflect a point of view, correct?
They reflect, yes, they're seeking to.
The memos in this case betray the occasion that gave rise to their compilation.
Yes, but they're, again.
And the last one, the memos in this case omit at least some known datum. Because they're 9 pages rather than 109 pages, correct?
That is correct. But there's one factor missing, which is they wanted these facts made public. They wanted a process to go forward. They assumed that Mr. Waterman would ultimately see these facts, because if there was any kind of disciplinary proceeding, the IRS would be obligated to give it to him. So the idea that they're going to be chilled seems to me, they wanted a disciplinary proceeding, and they were well aware of the fact that if they succeeded, there was no way that they would not end up furnishing these memos to Mr. Waterman.
You done?
Finished, Judge?
Yeah, I have two questions. One is, how would you answer the questions I was asking IRS counsel about what a court does when we have a situation like this, or at least that I think we have, where we have a declaration that says essentially these memos are selective. The authors picked the facts that they thought supported their case. That's what she says. Yet when we've looked at the document, it looks like the Kurt Waldheim document. So what do we do? Is it a burden of proof issue, or is there? What would I say in an opinion if we were going to say, yeah, I understand the declarations say they're selected, but I've looked at the document and they don't look selected. They don't look deliberate.
Well, this court reviews the district court decision to know.
Yes, correct.
Right? So the fact that the district court may have seen this in a different light.
No, I'm not asking about the district court. I'm asking about the declaration, the agency's declaration. Don't forget, but I'm not talking about the district court.
Declaration is like any other piece of evidence. It
Right.
has to be valued and judged. And oftentimes judges don't agree with the assertions that are made.
So what should they have, that's a good point. What should they have put in this? What should Rollins have put in this declaration to convince us that this was in fact selective?
Well, I think
What should she have said?
Well, for one thing, there's nothing in the declarations that really speaks to harm under the.
No, I understand that, but setting that aside, what should they have said in addition to Marchetti selected the facts that he thought supported the case? What should they have said?
Oh, and I think she would have had to add something, which she didn't. And there is a concern that if these documents become public, there will be a chilling effect. And the next time Mr. Marchetti thinks that a practitioner is engaging in misconduct, he will not comply with the IRS's requirement that he report.
I'm sorry. Let me try once again. I understand your point about that they haven't shown that it would chill, but I'm asking you a different question, which is what should Rollins have said in it to convince us that this document, which I've looked at, is in fact selective? Should she have said, what should she have said? How could she have convinced me that even though I'm looking at what looks like a chronology, it's not?
I'm sorry, Your Honor, I don't have a good answer.
Yeah, okay. All right, here's my other question. I'm still completely confused about the alert. I'm sorry, that I just don't understand it. It says, here's what it says. It says, okay, OPR now sends a letter to a practitioner advising him of the issues presented. All it says is of the issues presented and gives him an opportunity to ask for more documents. In other words, that looks like the September 10 letter minus you get more documents. So that's why I asked both of you whether under the new rule, what he would have gotten, under the new rule, he would have gotten this statement of issues earlier. And then he could have asked for more documents. And that's the issue before us today. Now, of course, today it's before us under FOIA, but then it would have been before the IRS under its own regulations. That's why I said, all it seems to me it does is move up the date that he gets a statement of the issue. Is that wrong?
I think that is.
I just read it. It says.
I agree with your interpretation of the procedures.
Oh.
What I think is equally salient is that the the OPR found the decision below inconsistent with its commitment to provide practitioners a full and fair opportunity to respond to the allegations. Everybody knew the allegations had been provided to Mr. Waterman at that point in time. The question really is what else should have been provided in order to allow the process to continue. Look, part of the concern is fairness, right? We've been talking about fairness. How can a process be fair if you can't understand what the underlying factual basis?
What do we do if we think parts of the process were profoundly unfair, but the application of the FOIA statute was legally sound?
I guess you write an opinion in which I lose and you sort of upbraid the IRS, which is not what I would urge you to do, Your Honor. I think the better way to do it is saying there's something fundamentally wrong with this case. All the allegations have been released. They're very unkind to my client. He has no way to really defend himself. You all, I'm sure at one point or another, had to decide whether a complaint pled a cause of action. But the insight of Trombley and Iqbal is, you need to understand the factual basis for allegations in order to decide whether a case can go forward or not. And so I don't want to try your patience.
Judge Rogers, do you have any additional questions?
No, thank you.
I would urge this court to resolve this case one way or another. This is the 6th anniversary of this case. Literally, it was filed on September 12th. And thank you so much.
Thank you, Mr. Vlade. The case is submitted.
Case number 21-5195, Matthew D. Green et al. Appellants versus United States Department of Justice et al. Ms. McSherry for the appellants, Mr. Tenney for the appellees.
Good morning, Ms. McSherry.
I've advised the timekeeper that I'd like to save 2 minutes. May it please the court, Corinne McSherry for the appellants, Dr. Green and Dr. Huang. However well-intentioned, Section 1201 of the DMCA has burdened expressive activities from the beginning, and Congress knew it would, which is why it tried to fix that problem by building in a variety of statutory exemptions and punting to the Library of Congress to take care of the rest. But that attempt to solve one First Amendment problem only created others and reinforces Section 1201's fatal flaws. Let me unpack. First, Section 1201 directly burdens core expressive activities like accessing and sharing information, publishing books, making films, understanding and teaching about code, engaging in and sharing security research that protects all of us, and many other uses. Those burdens are content-based on the face of the statute. It says some people...
I'm sorry to interrupt you, but you talked about the face of the statute. Could you first start by responding to the government's argument that the only thing properly before us is the as-applied challenge?
I'm sorry?
The as-applied challenge. We don't have jurisdiction to hear your facial challenge.
That's incorrect, Your Honor. And the reason why is because the facial challenge and the court's ruling on that challenge is inextricably linked with its decision on the preliminary injunction.
But the government's point is they're not. One doesn't decide the other. They're independent. The facial challenge resolution doesn't resolve the facial challenge could resolve the as applied, but the opposite's not true.
I think the way the court should look at this...
is that right? What I just said right or wrong?
That's incorrect.
Okay.
So all of these challenges are before the court, and the court should start with the facial challenge.
Why are they inextricably wound up?
Yeah.
So the court's ruling on the... I might back up. I think it helps a little bit to understand the procedural posture here. When we first brought our case 5 years ago, we moved for a preliminary injunction motion same time as the government moved to dismiss. The district court decided it did not want to reach our preliminary injunction motion until it resolved the motion to dismiss. 3 years later, we got that ruling.
I don't mean to. I am interrupting you, but it's because we know.
Okay, I just wanted to explain why we're in this somewhat unusual posture that we're in. It was not necessarily our choice, but nonetheless, when
inextricably wound up.
But when we brought our second preliminary injunction motion, we brought it on all of the claims, including the previous claims. The court then denied that motion. But
it denied the preliminary injunction motion for the dismissed claims for the simple reason that those claims had already been dismissed.
It denied that motion by referring back to it. And also in its court order, it refers to... Let me take another shot at Judge Dale's original question. Let's say we find that you don't have jurisdiction, or we don't have jurisdiction on the claims that were dismissed, and we deny your preliminary injunction for the as-applied claims. This goes back to the district court. Eventually, there's a final judgment. You appeal final judgment. And on that appeal to our court again, are you going to tell us that the claims on appeal, which were originally dismissed, are claims that you cannot win on because they are inextricably bound up with the claims that you lost on the preliminary injunction decision? I think that we would be appealing both. You're not going to make that argument, correct? Yeah, I'm probably not going to make that. You're going to say that you can still win on appeal of the dismissed claims after final judgment, even if you lost today on the preliminary injunction as applied claims. That is correct. That is correct, Your Honor. That seems to answer the question of whether they are inextricably bound up. Well, I don't think that completely answers the question. And I would point out another basis for your court to review the facial challenge, which is that in First Amendment cases, the court has a special obligation to review the whole record and consider the whole record to ensure that there has not been a First Amendment injury. And I would submit to you that my clients are suffering ongoing First Amendment injury right now, having waited for 5 years to even be here and able to get injunctive relief. We have that ongoing injury happening, not just with respect to my client, but with respect to all of the third parties who are not before the court right now.
I'm going to shift topics unless Judge Tatel or Judge Rogers has a jurisdiction question. Let me give you a hypothetical. Let's say that I am able to develop a code that allows me to break into ATMs and get as much money from those ATMs as I want. Now, let's say I want to traffic in that code. I want to sell it or even just give it away. And I make this argument. There will be some times when the code is used by a person who has money in the bank and will only take out as much money as the person has in that bank. Sort of the fair use analogy. But of course, we all know there will be plenty of times when someone uses that code to take money from the ATM that is not the amount of money that that person has in the bank. Do you think I would have a First Amendment right to traffic, to sell, to share that code?
I think that if you wanted to engage in that activity, it would have to, if you wanted to share the code for purposes of educating others, then I think what you would have to do is you would apply First Amendment scrutiny to that activity. Now, it may be, we'll see what the results of that scrutiny was, but it would still be because code is, it has.
I think I understand. Your answer is that I said, would you have a First Amendment right to sell that code? And your answer is maybe.
My answer is you would have a First Amendment right to appeal, ask for First Amendment scrutiny as to whether that activity was okay.
I'm asking, would you win in your First Amendment claim? And I think your answer is maybe. You don't have to answer. You don't have to say yes or no. It may be that the correct answer is maybe. I'm just wondering.
I'm trying to avoid fighting the hypo, but I think really what you would be doing if you were sharing the code is you would be sharing instructions for how to do something. And that is activity that's infected with expressive purpose and therefore it's covered by the First Amendment.
Maybe you would have a successful First Amendment.
I think it might be a challenge as applied, but that's certainly not the situation that we have here with the DMCA because it reaches far, far beyond that.
Let me ask one more question, then I can get out of my colleague's way here. Based on the complaint, how much of the code did Dr. Green plead that he wants to include in the book? Some of it or all of it?
What Dr. Green would like to do would be to include snippets of code.
Just snippets.
Just what?
He would like to include sections of code enough to show how he circumvented.
Well, if someone had got that, would someone with that amount of code be able to use it effectively to access copyrighted materials?
Someone would be able to use that code to replicate his research. And so potentially, yes. I mean, that is part of what you have to do to circumvent.
So what difference does it make if it's only part? Your whole point is he's going to deliver enough, put in a book, enough code for people to avoid copyright restrictions, right? In other words, if I picked up his book, I could use his code to download an ebook and not pay for it, right?
Not necessarily, Your Honor. He does need to release enough for others to be able to replicate his work. So he would need to release enough so that they too could circumvent. How that
just
would
answer my question about the ebook. Is there enough code in there for me to download a copyrighted ebook?
I think if you were technically sophisticated and able to implement that code in a way that most people are not, possibly. But the idea, his audience is going to be other researchers and the public, not for purposes of engaging in any kind of infringing activity, but to actually share information that will help people be more secure.
He can do that under the existing exemption he has. The only reason, maybe I'm wrong about this, but he has this exemption, right? He can do that. He's got this quote temporary exemption, so he can do all that with his code. He can use it for research. What he can't do, or at least what he thinks the statute prohibits him from doing, is violate the anti-trafficking provision, right? That's what this is about from his point of view. In other words, if if there's a potential violation of the statute for him, it's not of the anti-circumvention provision because he has an exemption. It's the anti-trafficking provision, right?
It is certainly primarily the anti-trafficking exemption. I would if I
Why do you say primarily?
In addition, so Dr. Green is covered by a temporary exemption.
Yeah.
But starting next fall, he and many other people are going to have to go back to the Library of Congress once again for permission.
Okay, but that's not before us now. Who knows what's going to happen? He claims now that this statute, the anti-trafficking provision, violates its First Amendment rights, and that's the question before us, right? Can he put the code in his book? Is it a sufficient amount of code for people to actually circumvent the copyright restrictions, right? That's what this is all about, isn't it?
That's most of it's about with respect to Dr. Green, if you choose not to reach the facial challenge.
Yeah, let's assume we're not exactly. Well, I didn't say exactly that's right. I said yes. My question is based on the as-applied challenge. Okay, and Mr. Wong, your brief lists all kinds of different activities that people won't be able to undertake with this this net VCR device, right? But these are all examples of other people's speech that could be facilitated. From his point of view, what he's prohibited from doing is using his this code he's got, this VCR thing. He can't sell that. That's what he says he can't do, right? And that's your First Amendment claim, isn't it? You can't make a First Amendment argument on behalf of people who aren't here. The question is his First Amendment right restricted? And your argument is yes, he can't sell his, what do you call this thing? Something VCR. What is it called? It's the
net TV.
His net VCR. The net VCR. Isn't that what your case is about?
No, Your Honor. So Dr. Wang, first of all, is burdened under A1 as well as A2, so not just trafficking, but his ability to access code for his own personal use. He wants to engage in digital analysis for his own personal use.
Well, he could apply for an exemption. He could apply for a temporary exemption.
He did apply for an exemption and it was refused, which is why he in particular raises questions about the speech licensing regime that Congress put in place in the form of the Library of Congress rulemaking. He tried to use that process. He went through all the burdens that process involves, and he was denied. So he is concerned about that process as well, not just the traffic.
I see.
And I would point out that the device that he wants to share, he wants to do two things. One is he would like to share code so that people who already have the net TV can upgrade their to a net TVCR, and also because he wants to share the code in such a way that others can edit, comment, redo it, make it better, make it more effective. So he wants to share code as well as marketing a device. But again, he is also burdened himself in engaging his own expressive activities and also in having received a pretty peremptory denial for his request from an exemption. The Library of Congress said, there aren't enough of you to be worried about this particular use, and therefore we're not going to give you an exemption, which is a fine example of how the Library of Congress exercises pretty unbridled discretion with respect to what kinds of exemptions it's going to offer, what kinds of exemptions it's not, which again is content-based in the statute. You can see it. It's written in there, the Library of Congress must favor some purposes over other purposes, some uses over other uses. And in practice, that's exactly what it does. You can make a documentary film, but you can't make a Western or many kinds of narrative films. That's what happens. You can engage in some kinds of protected activities, some kinds of educational uses if you are teaching in K to 12, and so different rules apply to K to 12 than to apply to university professors. There are the history of the rulemaking, which is in the record, is riddled with these kinds of exemptions that are, in many cases, incomprehensible to the people who are trying to take advantage of them. They have to figure out how to comply. And,
you think that the court's case from the Supreme Court's case from last term about the billboards, I think it was in Texas. You know the case I'm talking about? I'm sorry, I don't remember the name of it.
I couldn't quite hear.
The City of Austin billboards case.
Mhm.
Do you think that the court is beginning to give lower courts guidance along the following lines? Content-based versus not content-based, intermediate scrutiny versus strict scrutiny. These are distinctions that confuse more than they clarify. The proper inquiry is a look into history, tradition, perhaps analogies, in order to find out, is this the type of speech that has historically been protected or was protected at the time of the framing or the 14th Amendment or not? Do you think that's the guidance that they're giving us, or would I be reading way too much into City of Austin?
I think that what the court has been doing over the past decade, and I might begin with Terrell, but of course Terrell and Reed, I think what the court is trying to do is give guidance as to what you should look at when you're looking at a statute, and it should not just be the motive of the government, which may not be apparent on his face, but whether certain kinds of speech are being called out, because the roots of the First Amendment is a care to ensure that we don't have a position where the government is favoring certain kinds of speech over others or certain kinds of speakers over others. And
so a caricature of Reed, which I'm not endorsing, but it would be, is it content-based or not content-based? In Reed, it's content-based. Therefore, we turn on the switch for strict scrutiny and the government loses. And City of Austin seems to cut back on having that much hinge on whether it's content-based.
I don't think that's how I would interpret what the court is suggesting there. I think what the court is asking in City of Austin is this the kind of intervention, and is this the kind of rule that we should be worried about particularly, and trying to inform that. And I would suggest in this case, it's exactly what we have here. And 2 decades shows it. We have a government official exercising extraordinary discretion based on very unclear standards. They get to just consider adverse effects and such other factors as they might want to pay attention to. And it's very unclear. It changes every 3 years. The rules change every 3 years. And attorneys, student attorneys, and people all over the country then have to go to the office and go through basically a mini motion, and with briefing and defense and witness testimony and all of these things, and then wait for years to find out if they get an exemption or not. That's what Dr. Wang had to do.
Let me just focus on I want to follow up on Judge Walker's question about the City of Austin case. But okay, so if I'm looking at just one and just the anti-trafficking, so his device or his code, as I understand it, which he wants to sell, will enable purchasers to circumvent copyright protection, right? So set aside the research. I understand your point about that and all the standards and that he wants to research, but just this part of the case. That is, he wants his code, he wants to sell a code that will enable people to circumvent the copyright, right?
For non-infringing purposes, correct. Or I'm sorry.
Well, wait a minute. So for non-infringing purposes, if I buy his code, am I going to be able to download an ebook for free?
Not necessarily. What you would be able to do is be able to take your ebook that you already have and actually fully investigate the software in it and potentially improve upon that software. So it's actually more.
You're telling me then that his device. So suppose I download a library book. Okay, and let's assume that the library book is good for 21 days. Would I be able to circumvent that with his device, with his code?
It would depend on the digital rights management that happens to be on the book. Potentially.
Sometimes yes.
Sometimes.
But sometimes yes. Sorry. Yes.
Okay. All right.
I'm not a technologist.
So we agree that this code, you're agreeing with me then that his code can be used to circumvent a copyrighted provision, right? A copyrighted document or book, correct?
Yes.
Okay. So, and let's assume, I assume for a minute, I agree with you that code is speech, because I don't think the government's disagreeing with you about that. I mean, as I read the briefs, it's all about whether it's content-based or not. See them arguing it's not speech. So let's assume it is speech. Why isn't it completely controlled by the case Judge Walker mentioned, Austin, City of Austin? Because yes, you have to look at the code to see what it does, just as you had to read the sign in City of Austin. But it was a totally functional. All it did was it was completely functional. It was totally functional. That's all. It didn't. I'm just looking for the language here. Yeah, see, it ultimately, the distinction it made was not based on content, but on location. That was all. Just like here, it's not based on content, it's based on function, the ability to circumvent copyright. The cases seem identical to me.
So the distinction, Your Honor, is that what, with respect to whether it's content-based or not, we haven't reached intermediate scrutiny yet, but with respect to whether it's content-based or not, the difference here is that the code at issue here that he would like to provide directly, and the regulation against it, directly targets expressive activities, necessary predicates to speech.
Whose expressive activity?
His own, for one thing, and other people's. Well, expressive in the sense of he is not able to share this code.
I'm not talking about that part of the case. I'm only talking about his desire to sell this to people who want to circumvent the copyright. That's all.
So the sale of code is also expressive. But it also
I agree. I didn't remember I said to you, I'm willing to concede that it's expressive. I just don't understand why, given City of Austin, it's content-based. That's all.
I think the difference between City of Austin and here, in City of Austin, the question was based entirely on location. Right? And
but you had to read the sign to know whether that's what it was all about. And the court said that didn't make any difference.
Correct. But I think
that's just like here. You have to read the code to know what its purpose is, but its purpose is to circumvent. It's not content-based.
So in City of Austin, the question, what it said was the regulation itself does not call out content. It just calls out location. Yeah. Here we have a regulation that specifically does call out content, and on its face calls out expressive activities.
Yes. I have a question about standing, but before we do that, Judge Rogers, do you have any questions?
No, I think Judge Tatel's covered what
this is something of a friendly question, but to have standing, I think you need to show credible threat of enforcement or credible threat of prosecution. When asked the government about a sentence in a district court response, when it's the government's turn, but I want to read this sentence now so you can say why there's still a credible threat of prosecution in light of this sentence. Mm-hmm. This is from the government's response to the preliminary injunction motion, ECF 38 of the district court on page 35. The government says, the complaint's sparse description of Green's planned book, devoid of any factual assertions that would bring the book within the ambit of the anti-trafficking provision.
So what Dr. Green's declaration explains is that he would like to write a book, and here is how he would like to market it. And it's clear from the marketing he might to do that the fairly construed the statute could apply its prohibition on marketing or commercial gain to Dr. Green's activities. I would also point out the government has said twice that that it might be fine with Dr. Green publishing his research, and even aside with whether we have to trust the government's good behavior, which we know that we don't, and to decide this. Secondly, the government's been explicit that it believes that Dr. Green can engage in his research and publish his book without actually providing examples of code, which suggests that the government only thinks that he's excluded from the statute if he promises not to publish any excerpts of the code,
But
which
presumably
why he can't do.
his declaration that he intends to publish enough code for it to be used, circumvent, was within the complaint or would have been covered by the government's position that the complaint is devoid of any factual assertions that would bring the book within the ambit of the anti-trafficking provision.
I understand that the government says that, but that is not a fair reading of the statute. And we know that the way you have to read the statute is what it could reach, not what the government imagines it might reach, or promises it will do or will not do. And frankly, the Library of Congress has conceded. I'm sorry. What we know is that he needs to share enough because of the, and this is in his declaration, he needs to share excerpts of code so that other people can replicate his work and improve on his work. That is how security researchers engage in discourse. That's what they do. And
it sounds like your argument is there's a credible threat of prosecution because he is violating the statute. He wants to violate the statute.
He wants to violate the statute as it's.
It's not the entire Susan B. Anthony test for whether there's a credible threat of prosecution, though, right?
I think that we're in a posture, and the district court also seemed to accept this posture, that if the government promises that it doesn't think there's a problem, there's not a problem. And that I think is not, and it's from our position, the question is whether the statute fairly construed inhibits speech, and it most certainly does. And in fact, what you also can see from Dr. Green's declaration, it's not only his speech that's inhibited. There are people in his field that have simply left the field altogether because they're concerned about it.
Judge Tatel. Judge Rogers, anything else?
No, thank you.
Thank you very much, Ms. McSherry. We'll hear from Mr. Tenney. We'll give you a couple minutes for rebuttal.
Thank you, Your Honor. May it please the court. Daniel Tenney for the government. I'd like to start with what Mr. Wong wants to do, because I think that clarifies both the operation of the statute and its evident purpose. The technology he wants to sell would allow anybody who had access to any video stream. So if you rent a movie, if you buy a movie on a DVD, if you access it online, to strip away the content protection so that instead of having an encrypted copy of the movie or one subject to the access restrictions that the content provider attached to the movie, you would have access to a free unencrypted copy that could then be used by you however you want, could be rapidly disseminated around the world over the internet at the click of a button. And that's what Congress didn't want people to be able to do. And the reasons that it wanted that was that it wanted digital providers to be willing to provide their works to the public without being afraid that they would be that the copies would proliferate. And so that explains both the basis for the statute and why both, in general and as applied to Mr. Wong, why the statute is perfectly consistent with the First Amendment.
Can you address this quote that I read earlier from the DOJ's response motion, the district court? The complaint's sparse descriptions of Green's planned book are devoid of any factual assertions that would bring the book within the ambit of the anti-trafficking provision.
Sure.
Do you still agree?
Yes, we do. And
so that means that Green has not described anything that would violate that he wants to do that would violate the anti-trafficking.
That's correct, Your Honor.
So if that's the government's position and Green's complaint says he has a legal right to do what you say he has a legal right to do, that would seem to check the box for Green's likelihood of success on the merits. It's the first factor in the preliminary injunction inquiry, right? He's likely to succeed on the merits of his claim that he has a lawful right to publish the book he wants to publish.
I don't understand. I mean, you can't bring a claim and say, here's the thing I want to do, and you get an injunction.
Right. So that gets into the standing question, but.
Well, no, I mean, he would, the claim on the merits is that the government is threatening to do something to him that's unconstitutional. That's his claim on the merits. And if he's wrong that the government's doing anything to him at all, then he doesn't have a First Amendment claim.
I'm open to being talked out of this, but it seems like the first inquiry is standing. So we first have to determine whether there's a credible threat of prosecution. The government's litigating position in this case would be one factor in that inquiry, but it's not necessarily dispositive. And if we get to the point where we find that there is a credible threat of prosecution in the future, and that therefore Green has standing, then we would address the four factors that go into whether he's entitled to a preliminary injunction. The first of those factors would be whether he's likely to succeed on the merits of his claim that it's legal for him to publish the book that he wants to publish. And at that stage, we would say it is legal for him to publish the book that he wants to publish, if only because the government has conceded that it is.
I'm not trying to quibble here. The parties agree that it's legal for him to publish the book that he wants to publish. His claim is that the Digital Millennium Copyright Act is in some respect unconstitutional. That's what he's asking the district court to say. And he's asking the court to issue an injunction against the government.
Can I just interrupt and just a clarifying question here? So the code he wants to put in the book will not violate the anti-trafficking provision? Because counsel just told us that Green's code could be used by people who buy the book to circumvent the copyright.
Well, I mean,
that's your whole theory, isn't it?
I mean, I have a few responses. The answer to your direct question is no. We don't think the book would violate the
No, I'm talking about putting the code in the book.
Well, I mean, the thing is, the code in the book is something that's read by a human being, and then a human being, as I think opposing counsel also pointed out, a human being might take that code and turn it into something that might circumvent.
Now I'm completely confused. Okay, suppose it's a 100-page book. 99 pages of it are all about computer code and general analysis and history and technology. But one page has his code. And if I bought the book, I could take that code. I buy his book for $30. And with that code, I could then circumvent the copyrighted materials that Congress is trying to protect. Isn't that what he's saying he wants to do, and that the government that would clearly violate the anti-trafficking provision?
Well, I just want to go to the
if that's not true, then I've totally misunderstood this case.
I think that is what he's saying he wants to do. I think the anti-trafficking provision is a bit narrower than the question suggests. So I just want to go to the text of the provision, if I might. It's traffic in any technology, product, service, device, component, or part thereof. And then there are three. It has to satisfy one of three criteria. It's primarily designed or produced for the purpose of circumventing a technological measure. It has only limited commercially significant purpose or use other than to circumvent a technological measure, or it's marketed by that person for use in circumventing a technological measure. So the point is that, first of all, it's not even clear that a book is a product, service, device, component in the same sense. It's not like a computer program that you click the mouse and then you use the book to circumvent. You are a programmer, you read the book, it provides information to you, and then maybe with that knowledge, or maybe by copying some of the text of the book, you would create yourself a product.
I just want to get crystal clear on the record. Is the following statement correct? It's legal for Green to publish his book, even if the book includes enough code to allow someone to piece together a circumvention technology. Is that correct?
That is correct.
So this is the weirdest posture for a case. Green is saying that what he wants to do will violate the statute. And you're saying what he wants to do will not violate the statute.
Yes, and the district court agreed with us.
I guess my question is, what are we supposed to do with that? Do you think he has standing?
What?
To bring his as-applied claim with regard to the anti-trafficking provision?
No.
And what's the argument for why he does not have standing to bring that claim?
Well, because the claim, it would have to be that he wants to engage in conduct that violates the statute. which he doesn't. And that, if the court
So let me stop you there. Imagine, I mean, we might have to write this. Imagine that the court concludes the statute does prohibit his book.
Then he would have standing?
Well,
I mean, then you would get to the credible threat of enforcement.
So would there be a credible threat of enforcement in that situation?
No.
So what's the argument for why in that situation, after the court has concluded that the statute prohibits his book, there is nevertheless not a credible threat of prosecution?
I mean, I guess you'd have to say whether if the government's consistent view is that it doesn't, then the government has said, we're not going to prosecute.
I mean, it's only the government's view in this one case. I'm not sure it would bind a future U.S. attorney. And even in this case, I'm not sure it's been the government's consistent view. I think it's not a criticism of you specifically, because there's a lot of paper has been filed on this case, a little water under the bridge, but I'm not even sure it's the government's consistent position in this case.
I think it has been. I'm not aware of a circumstance where the government has taken a different position. I mean, let me put this another way. If the government were to prevail in this appeal on the ground that Mr. Green's conduct that he, as described, I'm not saying any conduct that might be different, but as described in the complaint and in his declaration in this case, if the government were to prevail in this appeal on that ground, then of course we couldn't then turn around and prosecute.
I mean, maybe you could speak for whoever the next attorney general is, but
I don't think that the government, having litigated against the same litigant and persuaded a court to reject it.
That would help us decide Green's as applied anti-trafficking claim. If what you just said is correct, what's the best case to support that? I'm not saying you're wrong.
I would think judicial estoppel cases would help there. I'm trying to remember the names of them. I think New Hampshire is one of them. But I mean, before we get there, because we're not asking you to dismiss his complaint, he wants a preliminary injunction. Does he have irreparable harm that during the pendency of this litigation, he's going to be prosecuted for that? I mean, that has to be an easier question. We just shouldn't have to tarry long on Dr. Green, because he has basically two claims. One is circumvention, where he has an exemption. The other is trafficking, where the district court and the government agree that what he's doing doesn't violate the statute. So it should be clear enough that he doesn't get a preliminary injunction. How the district court handles, whether to dismiss his case entirely and he can appeal from that later can be taken up at another time. So I think that should put Dr. Green to one side. I want to focus on Mr. Wong, because
before you go into Mr. Wong, let me just ask you a question about both so that I understand what you just said. Maybe my oversimplification is the wrong way. Okay, they both have this line of code. Green and Wong. They both have a line of code. And according to the record and what counsel has said, that code can be used by someone who gets it, buys it, or reads it in a book to circumvent a copyright. Right? They both have that. They both have that capability.
I think so. I want to be careful about exactly what it means to use code that's written in a book, but I think I understand where you're going.
Yeah, okay. So, and the difference between the two of them is that Wong's net VCR device is the code. That's it. Whereas Green wants to put it in one page of a 100-page book. Is that what distinguishes? Is that why Green's okay and Wong isn't? Suppose Green's book was only 2 pages.
I think so, but there's a few distinctions that are baked into what you said, so I want to just unpack them a little bit to make sure we get all of them on the table.
Yeah.
One is that what Wong is sending people is a computer program, and so you or I could take that computer program and click on the mouse, and we know when we buy computer programs we can just use them, and we don't have to read them or understand them or know what they say. We just click them and they do things.
Right.
And
we hope,
right. They do things, whether they're what we want is a different question. And Green is not selling or providing anything like that. He's not saying, here's a thing that you just sort of click the mouse right here and then it decrypts the video. That's not what he's providing. What he's saying is he's got some text, and in the middle of that text, he says, here's the program, and you would have to know what to do with the program and where to put it and how to install it into whatever else you're doing. So that's one difference.
Okay.
Now, the other difference is the purpose for which it's marketed, and that's relevant on the text of the statute. The statute talks about whether the only commercially significant purpose or whether it's marketed for the purpose of circumventing. And what Green's trying to do, as I understand, and we take him at his word for this, is educate. He's not trying to circumvent. And the statute makes that textually relevant too. And so it's not so much the number of pages in the book, it's both the form in which the code is provided and the way and the way in which it's marketed and who it's marketed to and for what purpose. And those are all relevant on the face of the statute. And if you had any, and so that's why they're so different.
But I guess what's really confusing is after Congress has written a statute where it tries to define the term and what it means and gives you the 3 examples. Here, in Judge Tatel's careful questioning of counsel, I thought it was conceded ultimately that there was enough in the book to cobble it together so that a knowledgeable person could, in fact, circumvent the statutory restriction. And counsel said, well, there was also another problem. So I thought counsel was acknowledging that a literal reading, that just because I don't tell you how to get from here to New York, doesn't mean I haven't given you enough information by longitude and latitude about what trains and planes go that way. Doesn't mean I haven't undermined the whole purpose that Congress had in mind in trying to protect copyrighted materials. And it seems to me your argument, and maybe this is correct, is that is way too broad of a concession. That even if you could cobble together from Green's book, that's not his purpose. And so there's no problem with the circumvention issue. Long, on the other hand, is just sending it out there for me to use without cost. And I can click on the program and get the downloaded protected material. So I think it's an interesting argument, but I wonder, in other words, is the government's concession such that looking ahead to what might happen to this case in the future, it has taken this position that, at least when I first understood this case, did not necessarily follow from the plain text of the statute.
Your Honor, if I might, I'd like to go back to the plain text of the statute and explain why the idea that anything that might ultimately have the effect of allowing people to circumvent can't be the outer bound here. If you look
but have you added a subjective intent provision here? That even if people can do that, if I don't intend for them to be able to do that in writing my book, that controls.
Your Honor, we haven't added it. I just like to read again the 3 categories that Congress set out. The first is
for the purpose of. And just because I say it's not for that purpose, if it's obvious it can be used for that purpose, why isn't, you see Congress as having added a requirement that the court find a specific intent to violate?
I mean, Your Honor, Congress put in 3 categories and they are intended to, I think, capture what you are concerned about here, which is the first category.
It worked too, but not according to your reading.
I I'm not sure my reading really parts company with what you're trying to get at, but if I could just go through them. So
No, but my point is, counsel, you're saying if Dr. Green doesn't intend to circumvent the statutory restriction, he avoids any fear of prosecution by the government.
I don't think that's entirely true. I think that would probably take him out of 2A.
Yes.
Also have to deal with 2B and 2C. I think he easily
Yes.
satisfies those. So I'm not trying to say Dr. Green is going to be prosecuted here. But what Congress was trying to do is say, look, if you have a device and the purpose of your device, and this is A, if you design something to allow people to circumvent, that's you can't traffic in that. And then the second thing is, okay, if you have something and there's very limited commercially significant purpose other than circumvention. So maybe you say, oh no, it's not to circumvent, it's for this totally different thing. You say, yeah, but the only reason anybody wants this device is that they want to circumvent. So they're buying it for that. Then you can't do that either. That's B. And then C is if it's marketed for use in circumventing. So if you have something, even if it has a bunch of different purposes, but you say, hey, everybody, there's this great thing, you can use it to circumvent devices, you can't do that either. And there's reasons that Congress would want to do it.
You're reading a specific intent requirement, and you read B as what the recipient's intent is irrelevant.
I don't read B as having a specific intent requirement. And I don't know that it has to do with the recipient's intent other than the intent to do the thing that's described in B, which is if the recipient uses the technology to circumvent a technological measure, and it has limited commercially significant purpose other than that, then it's covered. And I mean, it makes perfect sense that Congress would do it this way. And this goes back to what I said at the beginning. What Congress wanted to avoid is that you sell devices so that people can just decide, okay, if I'm going to rent a movie, do I want to only have access to the movie on the terms that the person who rented it to me wanted to give it to me? Or do I instead want to have access to the movie in whatever way that I want? And I think a lot of people would buy, if both were legal, a lot of people would buy the second one. And Congress said, well, we don't want people to have that access. We don't want people to be able to take a movie that they rent for 48 hours and make a copy of it or view it on a device other than the one that they were sold permission to view it on. And that's what Congress was getting at. That's consistent with the First Amendment. That covers what Mr. Wong wants to do, and that's why Mr. Wong is not entitled to relief.
Okay, I understand your point about Dr. Green now, and about 20 minutes ago, I interrupted you when you were about to transition to Wong's case. So would you do that now? So as I understand the government's position, government doesn't argue that code isn't speech, right? You're just arguing it isn't content, correct?
Well, so the Second Circuit addressed this well in Corley. The code has sort of a functional component and a speech component. So at least some code does. So some software can be exhibited in a way that's readable by human beings.
Is this a difference between object and subject? What is it? It's a difference.
It's not. It relates to the difference between source code and object.
I'm sorry, source code and object code.
But the point essentially is, software is sort of a hybrid thing, at least in some forms. It's like, let's just take source code to make it simple. So source code is written in words, or computer language.
Right.
So programmers can read it. So that's one thing that it does. So you could write it and a programmer could read your code.
Right.
And that is what the Second Circuit said, and we agree is expressive if you write code so somebody can read it.
Right.
The other thing it can do is without anybody reading it, it can give instructions to a computer to do something.
Right.
And what Congress was worried about in this statute was that second thing, the functional thing. So Congress doesn't care if somebody can read it or not. If you had code that was just sort of ones and zeros and gibberish and unreadable by any human being, it wouldn't have any of the expressive content. But Congress's interest in regulating it would be exactly the same, because what Congress cared about was the functional capacity of the code to instruct a computer to do something.
Okay.
And that's why this is not a content-based restriction, because it's not concerned about the expressive content. In fact, it doesn't matter whether the thing being regulated even has any expressive content. It's regulating conduct, the breaking of the protective measures, and its regulation of that may have the incidental effect of making it more difficult to express things if you express things with computer code that also has this conduct, but that's an incidental effect. That's not the target of the regulation. And that's what the Second Circuit said in Corley, and that's what's happening here. And that's why, I mean, this case is easier than the City of Austin, because City of Austin, at least, they were regulating speech as speech. They were saying, here's what you can say and here's what you cannot say. And here it just happens to limit in some circumstances. And then, as we've discussed at some length, to the extent that they're regulating the expressive part, talking to other people, it's narrowed in significant ways.
So what about counsel's argument? I get that. I understand that. What about counsel? Because when I asked counsel about that in her argument, she said, oh, it's much broader than that. Mr. Wong wants other people to read his code and understand it. He wants to educate with it. What about all that?
Right. So we're not saying that it doesn't have any effect on expression at all.
Yeah.
We're saying it's an incidental effect and that it's amply justified by Congress's desire to regulate the functional capacity, the conduct that's involved. And the point is, yeah, you could have a program and you say you want people to read it, but if it also allows everybody to unlock every video that's sold by anybody with any encryption system whatsoever, and then to make copies and distribute them all over the internet at the click of a button, the district court properly held that Congress's interest in doing that is sufficient to override his interest in having people read his code.
Okay, and the difference between that and Green's is that Green's putting code in the book isn't anything like that, right? It requires knowledge. It requires someone who understands how to convert. It's not a device that you can hit a button and download a movie that's restricted, right?
Exactly.
That's the difference.
That's the difference.
All right.
Yes.
Great. Thank you. That's
the purpose of interpreting the statute. Statute uses the phrase purpose of circumventing in A2A. And when we're trying to figure out the meaning of that word purpose, do we look to the purpose of Green's book, or do we look to the purpose of the code in Green's book?
It's hard to divorce one from the other. I mean, the code as it appears in the book is designed to be read by a human being. It's not something that goes into a computer. And so the code within the book sort of has the same purpose that Green attributed to it also.
You see,
I'm not sure how easily you can separate those.
I'm not sure either. But Green says the purpose of his book is anti-circumvention. And the purpose of the code itself is circumvention. So it seems like the purpose of the book and the purpose of the code are opposites.
Well, the purpose of the book is education, and the purpose of the code in the book is also education. What he wants,
but he says the purpose of the book is to educate people about preventing circumvention, and the code educates people about how to circumvent.
Right. I'm not sure either of those things is covered by the statute. I mean,
yeah, but the point is the government, your position is it doesn't violate the statute, right? Yeah. We would have a different case if you said, if the government's position was this violates the statute. Then we'd have to figure all this stuff out. But I mean, given what I've heard today, would the right disposition of this appeal be to say, to remand it to the district court to dismiss Dr. Green's case because there's nothing he wants to do that violates the statute?
I think that's what should ultimately happen in this case. I'm not sure that's the disposition of this appeal. This appeal is the appeal of the denial of a preliminary injunction. So you can just affirm and say he's not entitled to a preliminary injunction.
Oh, I see.
And then, so that's why some of these questions we haven't fleshed out.
We don't have to get into the question under your theory of irreparable injury or likelihood of success on the merits or anything, because what he alleges he wants to do does not violate the statute, period, right?
Right. There are a number of legal doctrines you could use to make that point.
Name one.
But I mean, irreparable injury is an easy one. He doesn't have any, nothing's going to happen to him.
And I suspect his attorney is going to it up in a moment, Ms. McSherry, and if I were her, I would say there is irreparable injury because you might get prosecuted by an attorney general a year from now or 2 years from now who's changed their mind about the meaning of this statute.
I mean, I guess I have a few responses to that. But this is a preliminary injunction, so he needs imminent irreparable injury. That's sort of the simplest answer that doesn't get into the weeds of any of the statutory, analysis. We stand by our position about the statute. I'm not running away from it. But it's hard to imagine, given what's happened so far, that, while this case is still pending, if the district court and this court affirmed, if the district court denied a preliminary injunction and this court affirmed on the ground that what he's doing either is not violating the statute or the government saying that it isn't, that there's a sufficiently non-speculative chance that someone's going to turn around and prosecute him while.
And I guess that's actually the irreparable injury inquiry is there going to be irreparable harm between this moment and the conclusion of the district court's case?
Right. And especially given what's happened, it just seems clear
that makes sense.
That's not true. Unless there are any further questions.
Judge Tatel? Judge Rogers?
No, thank you.
Thank you very much.
Thank you, Your Honor.
Mr. Tenney. McSherry, give you 2 minutes.
No, it's been a long morning, so I will.
So why is Dr. Green, why is Dr. Green bringing this case?
Why is Dr. Green still in this case?
Yes, because the government just said, everything he wants to do is okay. And if we put that in our opinion, doesn't that give Dr. Green all the protection he needs?
Well, with respect, Your Honor, I actually think the government has been a little bit cagey about whether it's actually okay what Dr. Green wants to do.
It wasn't cagey just now. And
That's
suppose
right. Tried to clarify.
It's in F4, and it says no irreparable injury because the government has assured us that anything he says in his complaint wants to do does not violate the statute. Doesn't that satisfy him? And don't we just have to deal with Wong then?
Well, given that he has been waiting to publish his book for 5 years, and who knows how long it will be before this case actually ends, I think he does continue to have a credible risk because we may have a new attorney general and a new government.
Wait a minute. Do you think a future attorney general is going to look at a DC Circuit opinion that says everything he wants to do is legal and the government has said so, and it's going to say, wait, I've changed my mind?
Well, I think that
we do this all the time in cases where we build into an opinion a representation made by the government. And I've never, ever heard of anybody thinking that wasn't sufficient to protect the client.
Well, I do appreciate the government's representation, but what I want to be clear about is what Dr. Green needs to do, which is he needs to publish his research and also the code itself, because people will find other vulnerabilities in that code. So
Mr. Tenney just said he can do that. That's what he just said.
Well, I'm glad. I wish he had said that in a brief, or the government had said so in the brief.
Judge Walker quoted their statement in the district court where they said that.
That's correct. And
okay.
I do think
so
that helps
why are you surprised?
I do think that helps alleviate Dr. Green's concerns. However, it is.
You're trying really hard not to win this case right away.
Well, it's been a while, Your Honor.
You want to talk about Wong? Why don't you talk about? Why don't you use your, which I've consumed? I'm sorry for talking about Mr. Wong.
Certainly.
Yeah,
so I would like to make two legal points because I think we focus somewhat on the facts. One is that we've talked a lot about whether the regulation is content-based or not. And we haven't talked a lot about whether the regulation can pass intermediate scrutiny. And I would just say that the government just now explained the whole purpose. The government's purpose in passing the Digital Millennium Copyright Act was to protect the market for a particular set of works. 20 years later, and this goes directly to burden, the reach of the Digital Millennium Copyright Act, because it applies to copyrighted software, reaches far beyond any of the government's initial intent, and that goes to weighing whether we have a close fit to means and end. And related to that, the back and forth with the government leads me to invite the narrow construction that we proposed. If the government is really only concerned with marketing for infringing purposes and with accessing for infringing purposes, then an easy way to get there that resolves, for the most part, the speech concerns here now and going forward is to adopt the narrowing construction. And the last point I'd like to make is that going back to your question regarding City of Austin and whether we are getting guidance from the Supreme Court to really try to adhere in our jurisprudence to sort of historically protected speech, I would submit to you that fair use is absolutely historically respected speech and protected speech. And we have that affirmed recently in the Golan case and before that in Eldred, which stressed the importance of fair use in balancing the copyright clause and the First Amendment. And that goes back to the Constitution.
Thank you very much, Ms. McSherry. That case is submitted.
This honorable court is now adjourned until Wednesday, September 14 at 9:30 a.m.